Hello viewers, welcome to another show of Indo-American Passage. I'm your host and U.S. Immigration Attorney Dave Banad Viswanath with the Banad Law Offices, Banad Immigration. Remember, ladies and gentlemen, Indo-American Passage, visas, green cards, and how to get them is only on ITV Gold every Saturday Eastern Standard Time at 10 a.m. and on Indian channel HW News Network based in Mumbai. That's a digital channel. It's the largest digital channel in India and based out of Mumbai, HW News Network, which is at 8:30 p.m. That's India time. So it's 10 a.m. on ITV Gold on Saturdays, and at 8:30 p.m. in India on HW News Network. Ladies and gentlemen, this show is all about immigration, U.S. immigration law, and its intersection with politics, okay? Now, not every segment is going to be about politics and how it affects immigration law, but many times it will be. And in fact, today's show is going to be an interesting turn on that exact subject, okay? So in today's show, let's talk a little bit about the I-751 removal of condition application, okay? Now, these are petitions for individuals who have been married for less than 2 years when they get their green card, okay? Now, what the United States government did is, in an effort to avoid sham marriages, is what they created was what's called the removal of condition. So individuals who have been married for 2 years or more would get what's called an unconditioned or unrestricted green card. But individuals who were married for less than 2 years on the date of getting their green card would get what's called a CR1 or a conditional permanent residence. Now, for all intents and purposes, it's still very similar to a regular green card, right? You can travel with it, you can work with it. The time that you're in conditional residence counts towards citizenship status, but you must apply for, and it's usually jointly, apply for what's called removal of condition upon the end of the 2-year period. In fact, you have to apply for it within 90 days of 2 years of having your green card. Okay, so there's 2 points here on the 2-year number. One is if you've been married for less than 2 years when you get your green card, and if that answer is yes, then you have to apply for removal of condition within 90 days of your 2-year expiration of your green card. That green card will only be given for 2 years. Now, there have been clients and people who have come to me in consultation who have said that, you know what, I was married for less than 2 years when I got my green card, and I got a 10-year green card. Let me tell you this, ladies and gentlemen, as quickly and as clearly as I can say this. USCIS, Immigration Services, CBP, they make mistakes, okay? I'm telling you now, the law does not provide for individuals to get a 10-year unrestricted green card if they've been married for less than 2 years. If you do, I'm not saying your status, it doesn't count. What I am saying to you is that when you apply for citizenship, okay, I mean, I have a client right now that came to me with the same problem. When you apply for citizenship, an immigration officer gets their third look at you, okay, and they're going to say, wait a minute, well, in this case, it would be your second look at you. And they're going to say, you never applied for removal of condition. And you're going to say, well, no, I got a 10-year green card. And they're going to say, well, actually, you should have gotten a CR1. That was a mistake. You need to go ahead and file for your removal of condition, the 751 application. And you're going to find that citizenship application held, pending. If you have a really nasty immigration officer, they're going to deny your citizenship, saying, you know what, you needed to get the 751. Having said that, though, let's explain this a little bit. The reason why it was created was to prevent sham marriages. You know, in the 80s and maybe even in the early 90s to some degree, late 90s, you definitely saw some of it. There were these sham marriages that were created. People were paying up to $70,000 for someone to marry them, you know, file paperwork for them, and then they get their green card. Oh, hooray. And then they would get divorced right after their green card came through. So what Congress created was this conditional permanent residence. Now individuals, what they have to do is they have to file for permanent residence if they've been married for less than 2 years. Then they file for removal of condition 90 days, within 90 days. Okay, so you can file, technically speaking, you can file even up to 1 day before your green card expires for removal of condition. And that's normally done jointly, meaning the original petitioner, the original American citizen who you married, along with the foreign national beneficiary. Children who benefited from this can also jump on board as ancillary beneficiaries. Or if they got their green card separately, then they can wait until their green card is about to expire and then file for their removal of condition. So there are a few options for derivative children. But what happens when individuals actually get married and then they end up divorcing, the marriage gets annulled, they end up, maybe the petitioner ends up passing away, sometimes, maybe their marriage just doesn't work. So in that situation, the individual cannot file jointly with their spouse, okay? They're just not possible. So what do? There is something called a waiver of joint filing, okay? A waiver of joint filing is something that individuals do when they're filing for their removal of condition, and they basically are going to ask the U.S. government to allow them on their own, meaning the foreign national, to apply for removal of condition. And in that application, they're going to give one of 3 grounds as a reason to waive the joint filing. One ground is that while they got married for all the right reasons, the marriage unfortunately terminated because of divorce, annulment, or someone passed away. The other ground is because it would be extreme hardship to the foreign national, okay? So there are situations where they may not even had a real relationship, or they couldn't prove it. They didn't have the burden. They didn't have enough evidence to prove the burden. So in that situation, what they would do is they would show that if they were not allowed to file with a waiver of joint filing, that it would be extreme hardship to them. Then there's the third ground, and that's where they have been subjected to extreme and unusual, or I should say extreme and cruel treatment, inhumane treatment by the U.S. citizen, spouse, okay? So, and let me just say this, in homosexual relationships, now they're legally recognized in immigration. So gay, lesbian, transgender, all of those categories of marriages, if you end up in this situation, you can still take advantage of these waivers of joint filing. So in the situation where a couple has been married, and we have, especially in the South Asian community, and to a lesser degree, but occasionally it happens within the Indo-Caribbean community, you may have people that have gotten married, through arrangements or a meeting by the families, or it just seemed to be the right thing to do. And, unfortunately, once the couple gets together, they realize that they just cannot be together, Sometimes they end up having children, which makes things much more complicated. Not so much from the immigration standpoint, but it does make things more complicated. But many times they don't even have children, Sometimes they haven't even consummated the relationship. So in that situation, what you're dealing with is an individual who they're no longer together. Maybe they separate. That's a very tough situation, okay? Because individuals who don't move forward with divorce, but they no longer live together, also get caught up in a situation where they cannot file jointly. USCIS will not approve an application for 751 removal of condition if an individual files on their own and they're only separated. Their marriage must be terminated. And I've had a few clients that came up to me and said, Mr. Dave, what do I do? Unfortunately, I can't get the divorce right now because this person is not being cooperative, or I can't find them. What do we do? Because my expiry date is coming up. In 2 months, I'm going to be, out of status. I don't want to lose my status. And I always explain to them that there are options available. We just have to see exactly what's going on. Maybe they're a good candidate for extreme hardship, that, look, they're trying their best. They're doing everything they can to file or to get the divorce finalized. Sometimes people file for divorce, but the American citizen spouse is being very difficult, or the foreign national believes that they're entitled to money, and there's some argument going on, so the divorce cannot be finalized. You cannot file, and I want to be very clear because unfortunately we do see, ladies and gentlemen, I'm on the grievance committee for the Queen's Bar, okay? So I definitely have dealt with issues related to attorney grievances. And unfortunately, there are attorneys that do tell people that, oh yeah, if you're separated or if you have a divorce that's pending, you can file a 751 application. And when your divorce is finalized, we'll go ahead and submit it. That's absolutely false, okay? And I want to be very clear about that. You cannot get a 751 with a waiver of joint filing approved if you filed under bona fide relationship but ended in marriage, divorce or annulment, if you're not actually divorced on the date of filing, okay? And people that get the divorce before their interview, you're in for a rude awakening. They're going to tell you to refile, okay? Because you need to have been, your whole basis for filing the application was from the date of filing were you divorced. And that needs to be clear to folks. And some people say, well, what do we have to show, Mr. Dave? What do we have to show to prove to U.S. immigration that there is that there was a real relationship, but at this point we don't have anything to go on. Okay, our relationship terminated, or you know what, even worse, we got an annulment. So there are some, government attorneys who have argued at points, well, an annulment means there was no marriage to begin with. So how can you be eligible for 751? Complete farce. The statute and the regulations discuss very clearly that an annulment is counted in a 751 case. The reality of things is it's not easy to show immigration that. If you got an annulment because you're saying that you were duped into getting married, or they lied to you, or for whatever reason the marriage in effect should not have occurred, you need to be able to show that your intention, meaning the foreign national, your intention was at every stage to move forward with a legitimate life partner in your spouse. Okay, same thing with divorce. If you're showing that you want a waiver of joint filing based on a bona fide marriage, but it terminated through divorce or annulment, then you need to show without a shadow of a doubt. I shouldn't say without a shadow of a doubt. The burden isn't that high, okay? But you have to show with very good cause that the reality of things is that you are in a relationship, or you were in a relationship that was bona fide, that you intended to stay together forever, and unfortunately it just irretrievably broke down, or that your spouse cheated on you, or that your spouse was violent, or they wanted money from you, something had to have occurred, and you have to show that there was real things that you were doing to show a bona fide relationship. Like what? Maybe it's pregnancy, maybe it's children, maybe it's bank accounts, maybe it's that all of your finances were commingled. It's how did you present yourself to society, And we're not just talking about documents that you had when you originally got your green card. That's one thing. But you need to talk about the documents that show you had a real relationship after you got your conditional green card. What were you doing together? Did you have those joint accounts? Did you go to events? Did you go to parties? Did you go to legal proceedings? Did you ever get involved with a lawsuit where you were suing somebody jointly with your spouse? You have to think about all the things that show to the world that you're a real couple. And, immigration's not going to say, okay, no problem if you just show them pictures. You need to show them objective documentation. You can add pictures, you can add affidavits, but really what they want to see is a combination of that plus showing that you're putting yourself out to the world. If you've got social media accounts, that you're showing yourself as being married at the time, that you had joint accounts, that you had joint bills, that you were paying debt together. If you bought a house, you bought it together. If you rented an apartment, you had both names on the lease. Statements from your account should show. It's not just that you had joint accounts, but they showed a livable life. They show expenses for her and for him. They show that you were paying your bills out of that account. They show that your income was going to that account. And if it wasn't, you better have a good reason why. I've had clients come to me and they have legitimate reasons, but some clients have no reason why. They say, you know what, I didn't really trust him yet. I wasn't ready to. Well, if that's the case, we're going to have a very good reason why immigration should still grant the case, okay? Because if you're divorced now and you're saying when you were married, you didn't feel like you trusted that individual, so you didn't put your money into that account, there's going to be a question to be had there, okay? I know in your mind and in your family's mind, it might have seemed like the right thing to do, but really, immigration looks at things a little bit in a vacuum, Unfortunately or fortunately, depending on how you look at it, USCIS, Immigration Services, looks at applications in a vacuum based on the adjudicator's field manual, based on the paperwork that you're showing them, and then based on your interview if they need it, okay? And don't get me wrong, they're human officers, and they're definitely officers that take things into account. They take how you're presenting yourself. They take your story into account. But many times they have too many cases on their load. Their resources are limited, and little things like that will cause a big issue, and they're going to need something more to establish that you had a real relationship. I mentioned to you about extreme hardship, and I touched upon it. If for some reason you're just not able to file, like for example, your divorce is not finalized yet, but you're clearly separated and you have nothing to do with your ex-spouse, or spouse that you're separated from, your, estranged spouse. Then extreme hardship may be something to look into. If your spouse has been abusive to you, not just violently, but maybe verbally. Maybe they constantly berated you. Maybe they threatened you. Maybe they told your family, his family, maybe they blasted you on social media. Those are forms of cruel and inhuman treatment. And those are definitely viable options to consider when applying for, hardship or cruel and inhuman treatment. So, there are a few different options here. Now, I want to talk about something else that's interconnected, but not totally. I mentioned this before, which is citizenship. So let's just say that you've applied for your removal of condition, whether jointly or through a waiver of joint filing. And now you've realized that the application is just taking so long. Okay, so you applied for a waiver of joint filing, you waited your 2 years, now it's 3 years later. And some of you are saying, wait a minute, Mr. Dave, what are you saying? I filed for a 751 application, it took 3 years? Sometimes it does. I actually had a client who I'm still dealing with, unfortunately, for them. And they had an attorney in the beginning, and then they didn't have an attorney, but they filed for removal of condition back in 2010. Okay, I finally got a result from U.S. Immigration in 2018. He was interviewed at the immigration office in 2014. Okay, so 4 years after filing, they were finally interviewed. And then it took another 4 years, which also included me going down to the immigration office 3 times, sending 2 additional letters to finally get them to respond and give us their decision. And, these are just unfortunately parts of the bureaucracy, parts of the administrative process when things get delayed. And I will say to some of you folks, this is against the law in the sense that there is something called the Administrative Procedures Act. It's a federal law which says that, administrative processes should not be unreasonably held up. And if the client had come to me in 2012 or 13 or 14, I might have even considered filing a lawsuit. I suggested it to the client when we first met. But you can bring a federal lawsuit against immigration services when they're taking in an unruly or unreasonable amount of time. And they have no real legitimate explanation for why that is. But when we're talking about citizenship now, a big question comes up. So now, for example, you're an individual who filed for your 751 application and it was joint, okay? So you filed with your spouse. It was upon year 3 and you've already filed for your 751 application. It's not approved yet, okay? Year 3 comes around, okay? And now, for anybody who knows a little bit about citizenship or if you've gone through it yourself, you know that if you're married to a U.S. citizen and you got your green card through that person, you can apply for citizenship after 3 years, okay? So after 3 years of permanent residence, if you're married to a U.S. citizen, based on that marriage, meaning you guys have to still be together, you can apply for citizenship, okay? Now, in the situation where your 751 application is still pending, usually what will happen, and something that I suggest to clients to advocate for if I'm not going to be their attorney, and if I am, I'm definitely going to advocate for it, is for immigration to adjudicate both applications at the same time, okay? And they have every right and authority to do so. So you apply for your citizenship application, and during the pendency of that application, either 1, your 751 comes through, or 2, at the time of your citizenship interview, USCIS can adjudicate both applications together. If you're unfortunately in a situation where you find yourself where the file is not with that officer, sometimes that can be a little bit more difficult. And in that situation, I do urge you all at citizenship, just as a precautionary measure, to bring your 751 application with you and any correspondence related to it. Because there are times where immigration will come up, you'll go to the citizenship unit, and they're not even aware that your 751 application wasn't adjudicated until that day of the interview. So something to remember. But as I said before, they have every authority to grant the case and approve both on the same day. Now people say, well, okay, well, that's fine. That's in a joint filing situation. And that means you have to bring your spouse with you, okay, ladies and gentlemen? When you apply for the application and you go for citizenship, if you're in a joint filing situation, don't take it for granted. Bring your spouse with you. Keep them in the room if you need to. Keep them in the waiting room if you need to. Offer them up to the officer so that the officer can see them, okay? Now, let's talk about another situation. Let's talk about citizenship where you've already filed a waiver of joint filing, Okay, that means the individual isn't with their U.S. citizen spouse. Okay, they're not together, the person divorced, annulled, cruel and inhuman treatment, whatever the reason. Now you've applied for citizenship. You're not applying for citizenship after 2 years and then you're applying for citizenship, or 3 years, then you're applying for citizenship. You have to apply after 5 years. Now some of you are saying, well, 5 years, of course I'm done with my marriage and divorce and all that. No, sometimes it just doesn't happen. 751 applications, sometimes it just doesn't get adjudicated, okay? In light of that, if the 751 application is still pending and 5 years have gone by, you are within all rights to apply for citizenship, and at the date of your interview, have the officer adjudicate both applications. Sometimes people will get an interview scheduled for the 751 application while the citizenship application is still pending. Still, I urge you to either have an attorney, or if you feel that you're a good advocate for yourself, advocate on your own to have the officer adjudicate both applications together. You're going to need to get fingerprinted, and some of the process will need to have been done, but still, I think it's worthwhile in doing it. USCIS officers have the ability to adjudicate both both applications, and I would urge you to do so. But I'm also going to say this. If you have a waiver of joint filing in a 751 application, and now you've applied for citizenship, it's going to be much tougher, okay? So don't write yourself off. When you have a joint filing application of 751 and you're applying for citizenship after 3 years and you're still together with your husband or your wife, there are a lot of things that are already going for you, So if you show proof you guys are still together, you show your pictures, you show your baby's birth certificates, all that jazz, many times officers will allow it and be a little easier on the subject. When you're dealing with a waiver of joint filing, be prepared for that application as well as citizenship. Be prepared to get tested on all your civics and history. Be prepared to deal with all your U.S. taxes. Be prepared to deal with the relationship, meaning the underlying reason why you filed the 751 with the waiver of joint filing. Whether it be because of the cruel and inhuman treatment, whether it be because you guys were together for the right reasons but got divorced or annulled, whether it be because it's just extreme hardship on you. You need to be prepared to deal with all or whichever category you applied for the 751 in, okay? So your citizenship exam, your interview, is not just one aspect of it. It's inclusive of both applications in a much more real way. And the other issue, and maybe this is where I would suggest that an attorney can be very, very helpful, is that you have to understand the nuances of just real people, okay? The reality of things is adjudicating officers in citizenship may never have dealt with 751 applications before. And vice versa, 751 adjudications officers may never have really dealt with citizenship before. If you're lucky enough to have an experienced officer, and they do that in many of the USCIS offices, particularly in New York and New Jersey, Philadelphia, the officers that are doing citizenship cases tend to be a little bit more experienced. So they've dealt with adjustment of status applications, they've dealt with 751 applications. But there are some times where you'll find officers that have not, okay? And in those situations, you may need to educate the officer. You may need to step in and say, you know what, we need to have a supervisor in here because you don't understand the nuances of 751 application and how it relates to citizenship. You may need to have somebody, or you need to be an advocate for yourself that can bring memorandum in saying that it's totally a right to do. Those are things that you have to keep in mind, okay? One of the other things that you need to think about is, how does this affect my travel? A lot of people say, Mr. Dave, we filed for 751 application. They renewed my green card status while it's pending, but I don't have an answer. What do I do? Or now I'm applying for citizenship, but I don't have a green card in place. I just have a stamp in my passport, and I have a receipt notice that said my status was extended. No problem. You are still a permanent resident during the pendency of your 751 application, during the pendency of citizenship. What I would suggest if you're planning foreign travel, though, is that you look to also go to USCIS through an InfoPass appointment and apply for a stamp in your passport. Okay, that's proof positive that you are still a permanent resident. I would not suggest applying for a renewal of your green card. Some people would say, yeah, go ahead and do that. It's confusing. Immigration will likely not approve the application, so you're wasting your money. And the reality of things is you've already taken the steps. The 751 application is, in essence, your renewal. Until that's approved, you're not going to get another green card. Okay, so don't try to waste your time doing so. But if you do need to travel outside the United States, then I do urge you to make an InfoPass appointment and get stamped. Now, another thing that comes up is that, ladies and gentlemen, InfoPass is changing. Okay, we got an announcement about 2 weeks ago on this, right before Christmas, that InfoPass is changing. People are not going to be able to walk in, at least in New York and in, I think, New Jersey as well. People are not going to be able to walk in as easily to an InfoPass appointment at USCIS offices for emergency parole or for stamping and whatnot. What they're going to require is that people make appointments, even for emergency walk-ins, okay? What they're going to do is they're going to set up a provision online, and they're also going to provide a telephone number. So people are going to be able to call that number, provide the information to the officer, and assuming that the officer deems what they're saying to be of the level, they'll grant that person an opportunity to come in, they'll give them an appointment date, and when they go to USCIS, it'll be in the system. Okay, that's something that Immigration Services is doing right now. They're implementing it as we speak. And so for all of you at home, I want to just, forewarn you on that. Be prepared for that. Ladies and gentlemen, the time is up. Unfortunately, these shows, I go on with all this information, and I realize that our time's up. That's happened here. This is the first show in the new year, so I want to wish everyone at home a very happy and healthy, prosperous 2019. I hope that it's wonderful, all of you at home. Remember, ladies and gentlemen, this show is only on ITV Gold and on HW News Network. On ITV Gold throughout the United States, wherever ITV is shown, it's Saturdays, Eastern Standard Time at 10 a.m. That would be 7 a.m. on the West Coast. In India on HW News Network, that's the digital platform. It's on at 8:30 p.m. on India time. And that's in India, okay? So 10 a.m. Eastern Standard and 8:30 p.m. in India. Ladies and gentlemen, if you have any questions, please feel free to email me. My email is dev@banadlaw.com, dave@banadlaw.com, or you can reach us at our telephone numbers on the screen. I hope you enjoyed today's show, and we'll see you next time. Take care.